If the perception of threat was available on the day when he made the first application,
There need not be fresh threats, sir. Everyday threat.
no,
Yes.
no, it is continuing ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಿದ್ದಾರೆ. It is continuing right from day one ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ಈಗ ಓನ್ಲಿ ಎವಿಡೆನ್ಸ್.
ಈಗ ಓನ್ಲಿ ಎವಿಡೆನ್ಸ್.
ಈ ಎವಿಡೆನ್ಸ್ ತಗೊಂಡಾಗಿದೆಯಾ ನಿಮ್ದು?
ಎವಿಡೆನ್ಸ್ ಆಗೋದು.
No sooner the order is passed, evidence is recorded.
ಅದು ನನಗೂ ಗೊತ್ತು, ಮಿಸ್ಕ್ಯಾರೇಜ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ಕೆ. ಬಟ್ ಎಲ್ಲೋ ಒಂದು ಸಂದೇಹ ಇದೆ, ಅದು ಮಾಕ್ ಎಕಡೆ ಸಂದೇಹಮೋ ನೀವು ಅದೇ ಅಂದ್ರೆ ಹಂಗೆ ಕಷ್ಟ ಆಗಿದೆ. ಎಸ್ ಸರ್, ಪ್ರಸನ್ನ ಅವ್ರೆ
135
ಒಪ್ಕೊಂಡಾಯ್ತಾ ನೀವು?
ಇಲ್ಲ ಅಲ್ಲ, 481 ಡಿಸ್ಮಿಸ್ ಆಗಿ ಎಲ್ಲ ಮುಗಿದೋಗಿದೆ ಕತೆ ಇದು. ಅಲ್ಲ, ಅವರು ಒಂದ್ಸಲ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ನಮ್ಮ ಮೇಲೆ ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು. ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಆಗ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ ಅಂತ ನಾವು ನಾಟ್ ವಿ ಹ್ಯಾವ್ ಸೆಡ್. ಅಲ್ಲ, A1 ಎವಿಡೆನ್ಸ್ ಬೇಕಾಗಬಹುದು ಅಂತ ಹೇಳಿರುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ಒಂದಾಗ ಹೇಳ್ತೀನಿ, ಬೇಕಾದಷ್ಟಿದೆ. ಬ್ಲಡ್ ನಾವೊಂದು ಪೆನ್ ಡ್ರೈವ್ ಹಾಕ್ತಿವಿ.
ಪೆನ್ ಡ್ರೈವ್?
ಹೌದು,
ಈ ಕೇಸಲ್ಲಿ ಪೆನ್ ಡ್ರೈವ್
ಹಾಕಿದೀವಿ, ಇನ್ನೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಏನ್ ಪೆನ್ ಡ್ರೈವ್ ಸುನಿಲ್
ಮಾಡಿದೀವಿ?
ಕೇಸಲ್ಲೆಲ್ಲ ಬರೀ ಪೆನ್ ಡ್ರೈವ್ ತಗೊಂಡ್ಬರ್ತಾರೆ. ಎಸ್ ಸರ್.
While inviting my Lord's kind attention to the provisions of section 306, 307 and 308, I submitted to your Lordship that the condition precedent for the trial court to have proceeded to record the evidence of the approver to whom pardon has been tendered is acceptance of the pardon that was given. That is how, my Lord, at that point of time,
No, in fact, I have heard you completely.
I stopped it.
Yes, sir.
My Lord, I think I need not take your Lordship again and again to 306, 307 and 308. It would be useful for me to draw my Lord's kind attention to a couple of judgments of the Supreme Court on this point. May I straight away request your Lordship to kindly turn to the first judgment which I have given in my compilation. Lord, this is in 2009, volume 6, Supreme Court cases 498. ಕೊಟ್ಟಿಲ್ವಾ? ಅಲ್ಲ, ಧಾರವಾಡದಲ್ಲಿ ಸಪ್ರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರಂತೆ.
ನಾನು ಬಂದಿದ್ದೀನಿ ಅಷ್ಟು, ಪೇಪರ್ಸ್ ಬಂದಿಲ್ಲ.
ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡ್ತೀನಿ. Well, where is the question of deemed tendering of, acceptance of pardon?
It is his application seeking pardon. On that application, an order is passed, and on that order, he is now asked to tender evidence. If he is not accepting that, he will not tender evidence.
No, it is not like that, my Lord. The things have got to be done in the manner in which the statute provides. The statute requires him to do it. I am not finding fault with the accused. I am only finding fault with the court. With the court in passing this order. He may accept, he may not accept. That is not the issue. Whether the court has followed the set procedure as mandated under the law is the question now. But what the Supreme Court has said is, he has got to be examined in this full bench judgment, my Lord.
Yes.
Yes, my Lord, kindly go to page 88. In page 88, it is clear, therefore, that a mere tender of pardon does not attract the provisions of so and so. There must be an acceptance of it, and the person who has accepted the pardon must be examined as a witness. Where has he accepted it?
No, this is a criminal appeal.
Yes, my Lord. The law on the
law
point
true is criminal. Would this ground be available to in a criminal appeal?
My Lord,
In a criminal appeal, in case the
my Lord, the law
thing goes against you.
The law that could be made applicable, my Lord, in an appeal is it not applicable now? If this
482
is the law, my Lord, that has been laid down.
No, 482 proceeding.
What if, my Lord?
Let's
What
see.
if whether it is
Yes.
a 482 or an appeal under section 374? What if it makes? This is the law on the point. The law on the point is, come on, give him the pardon, treat him as an approver. Then, my Lord, you have got to examine him as a witness for the prosecution only after he accepts the pardon. Was he aware or was he not aware of the terms and conditions that would be imposed by the court, irrespective of whatever may be the condition which you are going to impose? Can he say, even prior to the imposition of the condition, look here, I am accepting the pardon on the terms or on the conditions which you are likely to impose or which you are going to impose? Can he say that? It can't be said
Yes.
like that. Can he dream? Has he got a magic wand in his hand to imagine to himself that these are the terms and conditions which the court is going to impose while accepting his application and tenders him the pardon? He could not have imagined. How he could have said, my lord, that no, whatever may be the terms and conditions you are going to impose, I am going to accept it and examine me as a witness? I don't think, my lord, that is
Yes,
would be my
yes,
responsible
next.
submission.
No,
My lord,
what is what doubts I want to clarify.
please. Even prior to accepting his application, how can he say, the accused can say, did he dream for himself that his application is going to be granted? He could not have said, whatever may be the terms and conditions that would be imposed, so that it could be deemed that he has accepted the terms and conditions, would be my respectful submission. Let me repeat at the risk of repetition. Subsection 3 of section 3.
So that I saw it.
Yes, obliges the magistrate tendering pardon not only to record reasons for doing so, but also to state whether the tender was accepted by the person to whom it was. One, he comes out of the case unscathing. It is as good as he being discharged in the case. Number one. Number two, he gets the immunity from prosecution also, despite the fact that he turns hostile to the prosecution after he being treated as an approver in the case. Kindly permit me to take your lordship to this paragraph. 112, ink page 112, paragraph 13.
Yes, sir.
From the foregoing discussion with reference to the relevant provisions in the code and the law laid down by the apex court, it can be summarized thus. The power to grant pardon enjoined under sections 306 and 307 of the code is a substantive power, and it rests on the judicial discretion of the court. The power of the court is not circumscribed by any condition except the one, namely, that the action must be with a view to obtaining the evidence of any person who is supposed to have been directly or indirectly concerned in or privy to an offense. The court has to proceed with great caution and on sufficient grounds, recognizing the risk with the grant of pardon involved of allowing an offender to escape just punishment at the expense of the other accused. But in other words, the pith and substance of the order which came to be passed by this honorable court on 4th of December 2024 is the application stands rejected. It is not a case of this honorable court setting at naught the order and remitting the matter back to the trial court for first consideration.
No, liberty was given for him to file fresh application if he needs.
I shall come to this.
Yes.
It is not a case of remand or keeping it alive, that application. That application dies. I'm sure your lordship would certainly agree with me. However, he has been given another chance and an opportunity to make a fresh application.
Correct.
There is no doubt.
In terms of the liberty grant.
In terms of the liberty that was granted. The second application died. No doubt. But as on the date of the filing of the second application, if the grounds that are urged in the third application was available and was brought on record in the case,
Res judicata.
even for criminal cases also, my lord, the principle of res judicata is applicable under section 301. That is how, my lord, the Supreme Court has said and this honorable court has said. Even otherwise,
Yeah, relying on forward construction.
yes. Well, now here, what he has got to make out in the third application or in the next successive application is a fresh grounds, not on the ground, on the very ground that was urged in his second application or in his first application. That is the law. Change in circumstance must be there.
There is one paragraph where I have said in my order,
Please.
the allegation of Nagendra Naik's client is that he is under threat. If he is under threat, it is a continuing cause of action, continuing circumstance. That would itself become a changed circumstance every time that threat perception persists, is what I have said, I believe.
Yes, ma'am. Yes, ma'am.
But
But if the perception of threat was available on the day when he made the first application,
there need not be fresh threats, sir, everyday threat.
no,
Yes.
no, it is continuing ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಿದ್ದಾರೆ. It is continuing right from day one ಅಂತ ಅಂದ್ಬಿಟ್ಟು. Well, I shall take your lordship to his application. that perception.
No, threat continuing from day one
How-
till the filing of the present application. It can continue to the next application also.
Also,
Yes.
then the second application at a point of time when the third perception was there was dismissed. First application at a point of time when the third perception was there was dismissed.
Res judicata ಏನ್ ಬರಲ್ಲ.
Arre,
Constructive ನಾನು ಹೇಳ್ತಾ ಇರೋದು. That is why I refer to forward construction.
yes,
Yes,
it comes.
that is why I refer. Sir, fourth clause, sir. That is constructive res judicata. Yes.
Comes into operation. Certainly it comes into operation. If I am able to show to your lordship that this so-called threat perception was there on the day when he made the first application, number one. Even he pleads in his application that about the threat perception being there to him. Even on the day when he made the second application, if there is an averment that existence of the threat perception to him is there. If application 1 is rejected, application 2 is rejected, application 3
No,
may not-
application 2 is quashed.
Quashed in the sense, well, ultimately
Rejected. All
rejected.
Yes.
Quashing is ultimately nothing but rejection of his application.
All right.
Well, just like this, my lord, the FIR, we will seek for quashing of the FIR and the FIR is,
Rejected.
that means it is no longer in existence.
All right. Yeah, no longer in
No
existence.
longer in existence, that's all. It goes, it vanishes. It vanishes, totally it vanishes. My lord, if that is the case, it could not have been granted. Lord, number one. Number two, a threat, my lord, can't be a ground for him or for the court to grant pardon under section 306 or under section 307.
7.
I'm sure your lordship would agree with me. A threat can't be a ground. The ground that is available to an accused to seek pardon, or a ground that is available to the court to give him the pardon, is not a threat that is being administered to the accused, but what is needed to be brought on record in the case, what needs to be seen by the court from the evidence that is available on record in the case is, but for the accused being treated as an approver, but for his evidence being recorded, it is just not possible for the prosecution to make out a case against his companion accused in the case, is the law laid down by the Supreme Court. But without his evidence, in other words, without,
You mean to say it is the approver's evidence alone now can pin down the accused and nothing else?
that is what the Supreme Court has said. I shall take your lordship now.
I'm afraid that stage has come.
Yes, my lord.
Yes.
Now he is examined as a witness.
He's examined as a witness, but whether other accused have been.
For the purpose of exercising the jurisdiction of the
That is
court.
that's why I said I'm afraid that stage has not yet come.
No, my lord, it has come now. But when the magistrate exercises jurisdiction under section 306, that is a primary requirement of law. Otherwise, he cannot exercise his jurisdiction at all. Witnesses turning hostile is no ground. During the trial, as my lord has pointed out, it is still to come. But here, for the purpose of granting pardon under section 306 of the CRPC, what needs to be seen by the court or what needs to be contended by the prosecution is, without his evidence, it is extremely difficult for the prosecution to bring home the guilt of the accused.
Which is that judgment, sir?
But may I invite your lordship's kind attention?
Are they disputing that?
ಇಲ್ಲ ಅವ್ರು ಹೇಳಲ್ಲ ಅದನ್ನ
ನಾಗೇಂದ್ರ ನಾಯಕ್
ಹೇಳಲ್ಲ.
ಎರಡನೇ ಅಪ್ಲಿಕೇಶನ್ ಏನ್ ಹೇಳಿದ್ರಿ ಅದೇ ಇರೋದು ಈಗ್ಲೂ. ಎಕ್ಸ್ಟ್ರಾ ಏನ್ ಹೇಳಿದೀರಾ?
ಅಲ್ಲ ಎಕ್ಸ್ಟ್ರಾ ಈಗ ಡೀಟೇಲ್ ಆಗಿ ಹಾಕಿದ್ವಿ.
ಮುಂಚೆ ಡೀಟೇಲ್ ಆಗಿರ್ಲಿಲ್ಲ,
ಮುಂಚೆ ಡೀಟೇಲ್ ಆಗಿ ಹಾಕಿದ್ವಿ.
ಸ್ಕೆಚಿ ಆಗಿತ್ತ.
That was the argument made. He has not disclosed what he is going to say.
Correct.
There are up to
Earlier that was
164
no
was
disclosure.
164 recorded.
ಈಗ
There he disclosed.
ಈಗ ಕಂಪ್ಲೀಟ್ ಡಿಸ್ಕ್ಲೋಜರ್.
Because there is no 164.
ಈಗ ಓನ್ಲಿ ಎವಿಡೆನ್ಸ್.
ಈಗ only evidence.
ಈ ಎವಿಡೆನ್ಸ್ ತಗೊಂಡ್ ಆಗಿದೆಯಾ ನಿಮ್ದು?
Evidence ಆಗೋದು.
No sooner the order is passed, evidence is recorded.
ಅದು ಕರೆಕ್ಟ್.
ಮಾಡ್ಲಿ,
ಹಾ.
ಅದನ್ನೇ ಕ್ವಶನ್ ಮಾಡೋದು ನಾವು.
ಎಸ್.
ಮಾಡ್ಲಿ.
ಸೊ ಎವಿಡೆನ್ಸ್ ಆಗೋಗಿದೆ ಈಗ.
Evidence ಆಗೋಗಿದೆ. Crossing pending ಇದೆ.
ಕ್ರಾಸಿಕ್
If ಆಗಿದೆ ಅಷ್ಟೇ, this court has stayed it.
ಅದೇ ಕ್ರಾಸಿಕ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಷ್ಟೇ, this court has stayed it. Intermortem is passed by this court. During vacation, my lord, an intermortem came to be
Yes,
passed.
yes. Justice Anant Hegde. Sorry.
Obviously, if this application is allowed, if my petition is allowed, my lord, it whole thing goes lock, stock and barrel.
Correct, including the petitions.
ಅಲ್ಲ, ಈ ಅಪ್ಲಿಕೇಶನ್ ಹೋಗುತ್ತೆ.
Application. ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ ನೋಡಿದ್ರೆ ಪೆಟಿಷನ್ ಹೋಗುತ್ತೆ ಅದು.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರೆ ಏನಂತಂದ್ರೆ, after the grant of the application, evidence has been recorded, that also goes ಅಂತ. Whole thing goes.
ಇಲ್ಲ ಅದಕ್ಕೆ He has had a very good lunch, ಅದಕ್ಕೆ I was asking.
May I invite your lordship's kind attention?
Yes. Hmm.
ಅದೇ ತರ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಬರ್ದೇ ಹೋಗ್ಲಿ ಅದ್ ನೋಡ್ಕೊಂಡು ಅಕ್ಯೂಟ್ ಅಂತ ಹಾಕಿಲ್ಲ ಸರಿ.
Then you should, all of you should give me one judgment. Under 482, I can look into all this. That his pardon, whatever evidence he is tendering, whatever contents of his application, I can look into under 482 and quash that evidence, what he is wanting to tender or the application. Or these factors would be a subject matter of appeal before, when in the event he gets convicted, before the appellate court, all these submissions could be made. Under 482 jurisdiction, I want a judgment. If not, ಮುಗಿಸೋದ್ರೊಳಗೆ ಏನ್ ಬೇಕಾರೆ ಅದು ನನಗೂ ಗೊತ್ತು, ಮಿಸ್ಕ್ಯಾರೇಜ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ಕೆ. ಬಟ್ ಎಲ್ಲೋ ಒಂದ್ ಸಂದೇಹ ಇದೆ, ಅದು ಮಾಕ್ ಎಕಡೆ ಸಂದೇಹಮೋ ನೀವು ಅದೇ ಅಂದ್ರೆ ಹಂಗ್ ಕಷ್ಟ ಆಗಿದೆ. ಸರಿ.
But this was a case of prosecution under section 308.
Yes, correct.
But in this case, the accused would contend before the court, look here, I have not accepted the pardon at all. How can you prosecute me? That is what I submitted to your lordship.
Yes.
He will have the double advantage. One, a discharge in the case because he came to be treated as an approver.
Yes.
Number two, he having not chosen to accept the pardon that was given to him, will not come out unscathed in the prosecution under section 308.
Yes, sir.
That is the advantage he was able to gain. The 102 Millet in the Andhra Pradesh High Court, this was a case of provisional jurisdiction under section 397.
Hmm.
There was also a case under section 306. Millet, page 112, his lordship would lay down the guidelines. In item number 7, his lordship would say, the reasons for tendering pardon must be recorded and also about the factum of accepting of pardon by the concerned. This is under section 397.
ಎಲ್ಲಿ ಕೊಡ್ಬೇಕು?
And that is the
ಬಟ್ ಲೀಸ್ಟ್ ಗಿಲ್ಟಿಗೆ ಕರೆದ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಗೊತ್ತಾ ನನಗೇನು ಗೊತ್ತಿಲ್ಲ ಅಂತ
ಹಂಗಲ್ಲ,
ಯಾಕ್ ಕೊಡ್ತಾರೆ?
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು ಹೇಳ್ಬೇಕು ಅದನ್ನ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹೇಳೋದು
ಅವ್ರಿಗೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ವಾಂಟ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್.
No. Prosecution has said, I shall take your lordship to the application.
Grant of approval is for the purpose of eliciting the truth or reaching at the truth. Whoever says it, if he is an accused, he is turned approver and his evidence is taken.
But I shall take your lordship to the application. The objection filed by the prosecution which says that without his evidence it is not possible for us to make out a case.
In the first instance,
No.
even now, ಅದು
Take your
ಹಾಕಿದೆ.
lordship to the statement of objections.
Why?
I shall take your lordship.
In
to
the same
statement of
breath, how can
objections.
you say you want pardon and it's not enough?
No, it is not that it is not enough.
ಮತ್ತೆ why that objection from you?
He is a crucial link. Without his evidence, I can't make out.
No, he is of course not a crucial lead so far as 120 is.
ಓದೋಣ.
ಆಯ್ತು, ನಿಮ್ಗೆ ಅವ್ರದ್ದು ಅಪ್ರೂವರ್ ಬೇಕೇ ಬೇಕು, ಮತ್ತೆ ಅದು ಸಾಲಲ್ಲ.
Well, that is why, my lord, I have produced evidence also before your lordship. The other evidence that is brought on record, I have produced it in compilation number 2. There are 8 eyewitnesses to the case. Do they say that it is not possible for us to make out a case against the accused? Number 1. The circumstances that are thrust into service by the prosecution to make out a case of conspiracy, but I have also said it, and I have produced the evidence also.
ಮಾಡಿದ್ರು.
ಹಾಗಾದ್ರೆ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ಬಿಡಿ ಈಗ ಹಂಗಾದ್ರೆ.
No, not is saying.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್
No,
ಹಾಕಿರೋದ್ರಿಂದ
ಅಲ್ಲ,
at every stage of the proceedings an order of
said.
ಅಲ್ಲ, if they contend this is not sufficient, then come on, let us go back. Let me have the benefit of an order of discharge, or let the proceedings be dropped. But in 482, your lordship would pass the proceedings. When once one accused is acquitted or ordered to be discharged, your lordship does not allow the other accused who has not undergone the ordeal of trial, proceedings against him is quashed solely for the reason that the companion accused of the petition before your lordship has already been acquitted.
Depends
On the
on-
same set of facts and evidence.
Depends on the allegation.
Yes.
Yes.
ಅದಲ್ಲ ಅಲ್ಲ, ನಾನು ಹೇಳಿದ್ದು ನಮ್ಮ learned friend Mr. Prasanna said,
Yes, sir. ಪ್ರಸನ್ನ ಅವ್ರೆ,
135.
ಒಪ್ಕೊಂಡಾಯ್ತಾ ನೀವು?
ಇಲ್ಲ ಅಲ್ಲ, 481 ಡಿಸ್ಮಿಸ್ ಆಗಿ ಎಲ್ಲ ಮುಗಿದೋಗಿದೆ ಕತೆ ಇದು. ಅಲ್ಲ, ಅವರು ಒಂದ್ಸಲ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ನಮ್ಮ ಮೇಲೆ ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು. ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಆಗ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರೇನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ ಅಂತ ನಾವು ನಾಟ್ ವಿ ಹ್ಯಾವ್ ಸೆಡ್. ಅಲ್ಲ, A1 ಎವಿಡೆನ್ಸ್ ಬೇಕಾಗಬಹುದು ಅಂತ ಹೇಳಿದ್ರು. ನಾಟ್ ಸಬ್ಮಿಷನ್ ದಟ್ he made which is not there in my statement of objections which I'll bring to your lordship. ಅವ್ರಿಗೆ ಇದೆ ಅನ್ನೋಂಗಿದ್ರೆ ಓದ್ಲಿ ಎಲ್ಲಿದೆ ಅಂತ.
But may I just request your lordship to kindly turn to his third application.
We'll continue at 2:30 tomorrow. Yes.
ನಾಳೆ
ನಾಳೆ ಮುಗಿಸ್ಕೊಂಡು ಇಲ್ಲ ಅವ್ರು ಮಾಡ್ತಾ ಇರ್ಲಿ.
ಅವ್ರು ಮಾಡ್ಲಿ.
ಹಾ.
ನಾನು ಗುಲ್ಬರ್ಗ ಹೋಗ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು ಅವ್ರು ಮಾಡ್ತಾ ಇರ್ಲಿ, ಇನ್ನೂ ಇಬ್ರು ಇದಾರಲ್ಲ.
I'm back on Friday. Your lordship have done Friday.
ಅಷ್ಟೊಂದು ಲೇಟ್ ಆಯ್ತು.
ಅಲ್ಲ ರಜಾ, ಗುರುವಾರ ರಜಾ.
ಅಲ್ಲಿ ಗುರುವಾರ ರಜೆ ಗೊತ್ತು.
ನಾನು ಬುಧವಾರ ಅಲ್ಲಿರ್ತೀನಿ.
ಉಳಿದವರೆಲ್ಲ ಮಾಡ್ಲಿ ಅಷ್ಟಲ್ಲಿ ಮಾಡ್ತಾರೆ.
ಬುಧವಾರ ನಾನು ಅಲ್ಲಿರ್ತೀನಿ.
ಅವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ.
ಮುಗಿಸ್ಬಿಡಿ.
ಅವ್ರೇನು ಅವ್ರು ಒನ್ ಡೇ ಮಾಡ್ತಾರೆ. ಇನ್ನು he will definitely go on till Friday.
ಹಾಕ್ಬಿಟ್ಟಿದ್ದು ಶಾಮಸಂದ್ರ ಹೇಳ್ತಾರೆ.
ಬೇಡ ನಾಳೆ
ಅಲ್ಲ ಮಾಡ್ಲಿ ನಾಳೆ
2:30. ಎಸ್ ಅವರು ಮುಗಿಸ್ಲಿ, ನೀವು ಮುಗಿಸೋಂಗಿದ್ರೆ ಮುಗಿಸಿ.